Read a second time. I call the member for Newtown.
Thank you, Mr Speaker. I rise to speak on behalf of the Greens on the Serious Crime Prevention Orders Bill 2016 and the Criminal Legislation Amendment Organised Crime and Public Safety Bill 2016. The Greens oppose these bills. They are a threat to basic rights, individual freedoms and remove key protections from our criminal justice system. The Serious Crime Prevention Orders Bill 2016 allows the Supreme Court pre- or post-conviction and the District Court post-conviction to place restrictions on people or businesses involved in serious crime or terrorism offences. Application must be brought by the DPP, the Crime Commission or Commissioner of Police and can impose requirements or restrictions on the person if there are reasonable grounds to believe that the order would protect the public by preventing, restricting or disrupting the person's involvement in serious crime. The Court can admit and take into account hearsay evidence if it believes that it is reliable and relevant and the person, the subject of the order, is notified. Serious crime-related activity is defined as anything done that is a serious criminal offence, even if they are not charged or they are tried and acquitted. Involvement in such activity includes conduct that facilitates or is likely to facilitate another person engaging in a serious crime. Serious crime prevention orders can include prohibitions, restrictions, requirements and other provisions the Court thinks are appropriate to protect the public by preventing, restricting or disrupting involvement by the person in the serious crime-related activity. Orders can be for up to 5 years and breaching them, the maximum penalty is 1,500 penalty units for a corporation or 300 for an individual. That's $33,000 and 5 years jail. The bill includes provisions that allow corporations to be subject to orders to wind up companies and dissolve partnerships. The Public Safety Orders Bill 2016 creates a new power under LEPRA that allows a senior police officer to ban people from public places or events where they are expected to present a serious threat to public safety or security. The order can prohibit a person attending a specific public event or entering or being within a specific area or premises. The order can only be made if the officer is satisfied that the person poses a serious risk to public safety or security and the order is reasonably necessary in the circumstances. When considering the reasonably necessary, an officer must consider any history of the person engaging in the serious crime-related activity, if they are a member of a declared organisation or subject to a control order, the public interest in maintaining freedom to protest or engage in industrial action, if the order would stop a person being able to work, study, receive health care, if the content of the order is proportionate to the degree of risk posed and the extent to which the order will mitigate risk to public safety or security, especially compared to other measures reasonably available. A serious risk to public safety or security is defined as something that might result in death or serious physical harm to a person or serious damage to a property. Orders can be kept secret if the Commissioner, on application to the Supreme Court, if the application relates to a criminal intelligence report. And while a notification in writing is required, including reasons, must be served on a person, and if the person is under the age of 18 or has an impaired intellectual function on a guardian, it can be served on a guardian. It is binding even if that is not done. If the officer thinks that the order should be binding as a matter of urgency, they can communicate it verbally instead. Breaching an order can result in imprisonment for 5 years. There are also changes to make it easier for police to confiscate assets and deal with money laundering. It is clear that the changes proposed in these bills are broad-reaching and very concerning. But let us be clear on this. It is not just the Greens who oppose these laws. The Law Society of New South Wales has raised serious concerns about these bills, strongly opposing the passage of these bills as a rule of law matter and in order to protect fundamental rights and democratic institutions, stating, "The proposals under the bill appear to be an attempt to circumvent the usual protections of the criminal justice procedures. The Law Society considers that the extension of executive powers proposed by the bills would erode long-standing rights, including the presumption of innocence, the right to a fair trial, the right to property and the right to be protected against double punishment. The bills would also potentially place limitations on fundamental human rights, protecting against arbitrary arrest and detention and the freedoms of expression, communication and associations. The bills are also likely to compromise the integrity of the court processes and the Law Society submits that it would erode democratic institutions." The Law Society does not consider the bills to be appropriately targeted or at organised crime or community safety. As we have heard by other members in this place, the New South Wales Bar Association are just as strong in their oppositions to the bills. They say that the bill creates broad new powers which can be used to interfere in the liberty and privacy of persons and to restrict their freedom of movement, expression, communication and assembly. The powers are not subject to the necessary legal constraints or appropriate and adequate judicial oversight, and in many cases basic rules of evidence are circumvented. The question has to be asked why the New South Wales Bar Association, the Law Society and other legal and professional bodies around law enforcement agencies, civil liberties and human rights were not consulted on this bill. A process that would usually be handled by the Attorney-General, but in this case has not been done, and that consultation with those key lawmaking bodies, those key advisory groups, the human rights organisations and civil liberties organisations, has not been undertaken. In his second reading speech, the Minister said that, and I quote, "The purpose of these bills is to deliver on the government's election commitment to introduce tough new powers to give police the upper hand in the fight against serious crime." The Minister, in the same speech, also provides perhaps the most compelling argument as to why there is no need for these laws. He stated in his second reading speech that within New South Wales, strike forces Talon and Raptor have been effective in curbing gun and organised crime, arresting more than 4,400 persons and seizing more than 1,000 firearms. These broad-reaching and seriously concerning new powers are not necessary. They undermine fundamental principles of the criminal justice system, of the right to the presumption of innocence, the right to a fair trial, and protections against double punishment. Rather than creating new powers and offences, police resources should continue to be directed towards solid, effective police work.